Okay, my name is Muhammad Kamazam Jali, uh, a student of International Relations. Okay, for the International Criminal Law class, I will discuss about crime of aggression. Okay, okay. What can be defined as aggression? What is the crime aggression? Aggression is a crime under international law, although there is no universally agreed definition and no international court or tribunal which can try offenders. Apart from that, any act of aggression, including the employment by the authorities of a state of armed force against another state for any purpose. Okay, now we will look to the historical development of crime about the crime of aggression. Okay, uh, after the World War II, the drafting of the London Charter made clear that it was by no means a widely held view that there existed a crime of aggression under international law as it then stood. And if we move on to the Nuremberg IMT, International Military Tribunal, war is illegal in international law, and that those who plan and wage such a war will, if inevitable and terrible consequences, are committing a crime in so doing. Now we go to the Tokyo Tribunal. Judge Rowling and Paul, in their dissenting judgment, disagree. Indeed, the 1928 Pact has not intended to give rise to individual criminal responsibility, but whatever the merits of the decision by the two tribunals as to the status of the crimes after the Second World War, it is widely accepted that it is now a crime of aggression under customary international law. In the IISC, the first one is IISC elaborate a definition of aggression but did not succeed in reaching agreement. GA decided that the code raised problems closely related to that of the definition of aggression and postponed further consideration until 1952. IRC also adopted a draft code against the peace and security of mankind in 1996, Article 16. In Article 16, stated that an individual who, as a leader or organizer, actively participates or order the planning, preparation, or abetting the kind of aggression can be prosecuted under ICC Code. Okay. There's some procedure for crime of aggression. The first procedure is the perpetrator must be a political or military person. Political or military leader can be defined as a person in a position effectively to exercise control over or to direct the political or military action of a state. The second procedure is the court must prove that the perpetrator was involved in the planning, preparation, initiation, or execution of such a state and act of aggression. The third one is, or the final one is, a state act must amount to an act of aggression in accordance with the definition contained in General Assembly Resolution 3314, and it must by its character, gravity, and scale constitute a manifest violation of the UN Charter. Okay, we will discuss about the Rome Statute. Rome Statute discuss the definition of the crime of aggression in Article 8.1 and Article 8.2. Discuss the act that can be considered as the act of aggression. Article 8.1 means that the crime of aggression means the planning, preparation, initiation, or execution by a person in position effectively to exercise control over or to direct the political or military action of a state of an act of aggression which, by its character, gravity, and scale, constitute a manifest violation of the Charter of the United Nations. Article 8.2. The invasion of or attack by the armed forces of a state of the territory of another state, or any military occupation, however temporary, resulting from such invasion or attack, or any annexation by the use of force of the territory of another state or part thereof, bombardment by the armed forces of a state against the territory of another state, or the use of any weapons by a state against the territory of another state. C. The blockade of the ports or coast of a state by the armed forces or another state of another state. D. An attack by the armed forces of a state on the land, sea, or air forces or marine and air fleets of another state, inserted by Resolution 6 of 11 June 2010, the Rome Statute of International Criminal Court. The use of armed forces of one state which are within the territory of another state with the agreement of their presence in such territory beyond the termination of the agreement. The action of a state in allowing its territory which it has placed at the disposal of another state to be used by that other state for perpetrating an act of aggression against a third state. G. Descending mm, descending by or on behalf of a state and armed bands, groups, irregulars, or mercenaries which carry out acts of armed force against another state of such gravity as to amount to the act listed above, or its substantial involvement therein. Okay. The elements of crimes of the war of the crimes of aggression is the first one is the perpetrator planned, prepared, initiated, or executed an act of aggression. The perpetrator was a person in a position effectively to exercise control over or to direct the political or military action of the state which committed the act of aggression. The act of aggression, the use of armed force by a state against sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations was committed. The fourth one is the perpetrator was aware of the factual circumstances that established that such a use of armed force was inconsistent with the Charter of the United Nations. The act of aggression, by its character, gravity, and scale, constitute a manifest violation of the Charter of the United Nations. The perpetrator was aware of the factual the perpetrator was aware of the factual circumstances that establish such a manifest violation of the Charter of the United Nations. Okay, the case result. Almost all the trials for crimes against peace took place between November 1945 and November 1948. Okay, before the terms the crime of aggression took place, the crimes against peace is another name of the crimes of aggression. Okay, I will repeat. Almost all the trials for crimes against peace took place between November 1945 and November 1948, although in some cases, such as Romania, they extend into 1949. No one has been prosecuted for aggression before or since. The court faced the challenge first of proving the criminality of act of aggression, and secondly in trying such acts to individual. The closest question that may evoke crime of aggression to be prosecuted in the International Criminal Court is the current conflict with Russian invasion of Ukraine. However, The conflict of Russian invasion of Ukraine cannot be prosecuted in the ICC court, as Russia is not the member of the ICC, is not the member of the Rome Statute. If Russia, the member of the Rome Statute, Russia can be prosecuted under the ICC court. Okay. Crime of aggression is a crime that still can be defined until now. Because it involve the bigger power, a state, party, a state that have its own sovereignty. Okay, there are so many controversy for the crimes of aggression. The first one is crime of aggression scope is not specific and still be argued until today, as the traditional view is that only decision makers can be held criminally responsible for aggression other than lower level military personnel and ordinary soldiers, but consideration as to whether soldiers who knowingly participate in war of aggression incur moral or should incur legal liability. Crime of aggression is not like any other crimes, as it never been brought to any other court, including ICTY, ICTR, and the current court, ICC court. Whether waging aggressive war inherently violates the right of life guaranteed in international human rights. Apart from that, every state have their own sovereignty and punish them for initiating the war or invention which smear their sovereignty. Okay, if we look to the meaning of the crime of aggression, we can say that there is a concrete, not a concrete, a truth definition. There is no universally agreed definition, as there is no cases have been brought to the international court, including international court, the former of Yugoslavia, international criminal court of Rwanda, and international criminal court. Until now, ICC still have difficulty in defining the crime of aggression. Okay, now we move on to conclusion. Crime of aggression is still a dilemma in ICC, as it is very hard to bring the case to the court. Crime of aggression is unlike any other crimes and needs the perpetrator to reach a grave breaches, and it can be said that the crime of aggression is more worse than any other crimes under the Rome Statute, such as genocide, crimes against humanity, and war crimes. Crime of aggression need to be prosecuted using the gravity and the action that be made that can be reached the grave breaches. The ICC court need to develop its statute, and the crime of aggression need to be defined as soon as possible to prosecute the state that violated the law and waging war to another state. And the ICC court need to take a maximum measure in prosecuting the crime of aggression, as it's involved in an important figure of the state. Crime of aggression is not like any other crimes, as it is the war. Its casualty can be extended to the millions of people, and its gravity can be considered as more heavy than any other crimes. Therefore, ICC court or the UN must take a considerable measure to define and to make sure that the crime of aggression will be prosecuted in a fair way and be used to protect the weakest state. That's all for me. Thank you.